gentlemen, I think we're going to get started. We only have an hour for this session, so and we have about 5 hours worth of information and material, so we want to get started. But I want to thank all of you for joining us here today. My name is Gabriel Eckstein. I am the chair of the Executive Council for the International Association for Water Law, and I have the privilege of welcoming you here to this particular session, which is Governing Groundwater Resources Under Uncertainty, Comparative National Groundwater Governance and Regulations. I want to begin by thanking all of our partners, and just to give you a sense how important this is an issue this is with groundwater resources. Our partners are International Water Resources Association, IUCN, World Commission on Environmental Law, Water and Wetlands Law Specialist Group. We have UNESCO-IHP, which is a partner on this, IHE-Delft, Institute for Water Education, Texas A&M University, School of Law, and also the Groundwater Project. All of these are partners in this particular sessions because everybody recognizes the groundwater is such a critical issue. And the purpose of this session is to explore national groundwater governance and regulations in a comparative fashion because we wanted to try to get a better understanding of the opportunities that we can have in terms of groundwater management, and then identify what we might call good practices that will help us ensure the sustainable use of this precious subsurface resource. The program will begin with a keynote, followed by a brief description of a project that is being undertaken by the International Association for Water Law, which is on comparative groundwater regulations. Then we'll have a roundtable featuring some of the participants of that project, and they will be giving their perspectives on the projects and some of the outcomes from the ongoing project. We'll have a brief Q&A session, and then I'll return with some concluding remarks. To begin the program, we're going to start off with a keynote. I'd like to introduce Mr. Abu Amani, who is the Director of the Division of Water Sciences and the Secretary of UNESCO's Intergovernmental Hydrological Program. So thank you for joining us, Abu. We really appreciate your presence here.
Thank you very much for the opportunity to to contribute to this very important session. First of all, I would like really to appreciate all the effort of IDA for organizing this session. Of course, we are partner of this session. Of course, we all know the importance groundwater has for communities worldwide. In many regions, for example, in Africa, groundwater is the main sources of water for people when it comes to water supply aspect, and also the critical importance of that resources for other sectors, for agriculture, for the industry. But the most important point here is the fact that we all know that despite this critical importance groundwater has, is unfortunately overlooked, poorly considered within the policies at country levels. So this is why our work together to raise the profile of groundwater to be considered equally like the other part of the resources, first water, within policies is paramount. So this is why I really commend this work of IDA to explore comparatively groundwater legal regimes in nations and jurisdictions around the world is so significant. Within IHP, as you know, we have been at the forefront of groundwater work, contributing to raise the profile of these very important resources. Of course, the main milestone we may recall is the 2022, where we organized the UN Water Groundwater Summit in Paris, and also in parallel also we launched the Groundwater Development Report, making the invisible visible, really to continue doing that very important effort. But most importantly also, as you know, UNESCO-IHP has been accompanying the UN commission for law regarding the articles, as you know, of transboundary groundwater management. And in that regard, I think the key point here is how to domesticate those articles at national level, working together in also making relevant the importance of groundwater. Concretely speaking, within UNESCO, we have some projects. Maybe I can highlight the example of the MED program. We have been working to take into account the groundwater within national jurisdiction when it's come to coastal aquifers. So this is a project we are working for integrating conjunctive management of surface and groundwater in Albania, Lebanon, Libya, Montenegro, Morocco, and Tunisia. So we organize dialogues with those key stakeholders in order really to raise the profile and also take into account groundwater when it's come to national policies and also the different plans for the sustainable implementation of those coastal aquifers. The other point I want to raise is concerning the background work we did together, as you may recall, in 2011, the groundwater governance project, which we led with World Bank, FAO, IHE, and IWRA project, which produced a comprehensive policy framework in how really groundwater will be managed properly at country level, at regional level, and also at global level. We still believe that those are reference framework which we should continue promoting at different levels. The other point I want to raise concerns the issue of access to data, because if you want to really have clear policy at national level where we can make groundwater relevant as equal to surface water, we need to appropriate data. And unfortunately, this is one of the missing links in many countries. And I want really to stress that critical importance of pushing government to put appropriate measures so that they can collect good quality data when it's come to groundwater. Because we need to make the invisible visible by clear monitoring, better information, and also the data need to be shared. This is one of the key main messages. It has to be shared, of course, among users, but when it's come to those aquifers who are going across boundaries, that information, the data that need to be shared across borders. So this for us is something which we believe is very, very, very important. Of course, we all know all the, when it comes to governance, the OECD governance, water governance principles, which are, I think, relevant. We need to take them into account within our discussions, because for us, really, the critical aspect is to stress on the inclusiveness aspect, the accountability, but most importantly, the knowledge base. Evidence-based decision-making is paramount if you want to achieve groundwater sustainability. Because if you don't know what you are managing, the risk is you can destroy it. And this, unfortunately, is more true than surface water for groundwater, because we're not seeing it. We are over pumping, we may pollute it, we even don't know, and at the end of the day, we have a system which is completely destroyed. The integrity of the system is completely destroyed, and then we lose it. So this is something for us which is extremely important. My last point is, of course, even though we are considering the national policies, I think we should not overlook the transboundariness of the resources. I've already alluded to the UN articles on transboundary aquifer management. I want to once again to reiterate the critical role of domesticating those articles at national level. And I want to commend the work of IDA on that regard, because moving forward, the issue of governance is an issue also of mobilizing people, but is also the issue of law and policy. So by ending, I want to once again to reiterate the commitment of UNESCO-IHP. We are ready to continue working with all of you to advance the agenda of groundwater, to make the invisible visible, but to make it a resource which is recognized as surface water, contributing to sustainable development, contributing to livelihoods, and also in preserving the integrity and also sustainability of water system at their own. So I want once again to thank IDA for organizing this session, and we are looking forward for the fruitful discussion during the session. Thank you very much.
All right, great. With that as background, we have wonderful remarks about the importance of groundwater, and we clearly recognize that and appreciate it. In IDA, we've taken that to the level where we are looking at these issues of groundwater from a regulatory point of view at the national level, whether it's looking at the specific regulatory regimes for implementing the local considerations and local rules, but also take into account the international obligations, whether they come from draft articles for proposed laws, but also other international instruments. How do you domesticate them, as Mr. Amani was saying? A really critical issue, and this is something that we're looking into at within AIDA. And one of the projects that I just want to briefly tell you about is the one that is the focus of this session, which is this comparative groundwater regulations at the national level. What we've done, we've set together a task force that is looking at the groundwater laws of different countries around the world and on particular themes. And we started with the first theme on what we might think is simple: ownership. Who owns the groundwater? And what you find is that it really depends on which country you might be in. It could be the government, it could be the public, it could be the landowner, it could be no one. There are countries where there's no ownership in the groundwater until you extract it. Well, what does that mean for management? What does that mean for regulations when the landowner owns it versus the government versus the public and so on? So this is what we're exploring, and in our first phase, we actually completed it. And we have our first report, which is being published in a professional journal. It's the Transnational Environmental Law Journal, and that's the one that's looking at ownership of groundwater. We looked at 10 jurisdictions in 5 continents. So we have a very broad array, and that should be published within the next month or two. We are now into phase 2 of the project, which we're looking at rights to groundwater, rights in groundwater, rights for groundwater, the different ways that you might formulate rights and groundwater together, and what does that mean for use? What does it mean for regulations? How do you interpret these, and what are the implications? And that's phase 2, that's ongoing. We've actually surveyed 15 jurisdictions, and that process is now being peer reviewed, and we'll be drafting the first report in, I think we'll be starting around February, and hopefully with the idea that we'll have a complete report by the summer, and then we'll again submit it for publication, for peer review publication. We are looking for partners in this effort, where we welcome other organizations that want to participate in this, and contribute, other individuals who might want to join IDA and participate in this project. And just to give you a flavor of what's involved here, I'm going to invite a number of people to the stage now, and these are some of the people who are actually doing the research on these projects. And so we're going to have Amy Hardberger, who is the George W. McCleskey Professor of Water Law and Director of the Center for Water Law and Policy at Texas Tech University in the state of Texas. We have Eric Garner, who practices water rights and supply law at the law firm of Best and Krieger in California. We have Gabriela Cuadrado Quesada, a senior lecturer and researcher of water rights and justice at the IHE-Delft program in the Netherlands. We have Juan Pablo Galeano, who's a lawyer in Argentina, a water lawyer specializing on water regulation and legislation. Stefano Berkey is an expert in comparative and international freshwater law, former chief of the UN FAO Development Law Service, and then also former chairman of the International Association for Water Law. And then Imad Antoine Ibrahim is also part of this project, and he's going to moderate this next session. He's an assistant professor of law, technology and sustainability at the Department of Governance and Technology for Sustainability at the University of Twente in the Netherlands. So please, if I could have all the speakers come up to the stage, and I will pass the microphone to Imad.
Thank you. Hi everyone. For our next 20 minutes, we're going to try to have some fun with this topic and try to push the boundaries further to understand what is exactly we're talking about when we say groundwater regulation at the national level. Why is it important? Is it actually important? We don't know yet. We'll see. What do we do with it? Can we govern it? So buckle up and let's see how that will go. So now we're going to start with the first question. So groundwater is not really just another source, is it? It's political, it's invisible. One would say it's explosive. So how do we govern something that is explosive like that when it comes to groundwater and compares it to other resources like surface water? Stefano, yes?
I have two answers to that question. One, what makes it more complex and difficult to regulate relative to surface water, what makes groundwater more difficult, is the fact that no matter what the law says, it is perceived as intensely private. It's under my land, so no matter what, I feel entitled to draw as much as I want from under my land, whatever the government says and whatever the law says. And the second issue is, relative to surface water, groundwater is much more prone to being impacted by whatever happens on the land above and in the subsurface space. And the impact is twofold, both on the quality of groundwater, because it's prone to being polluted by land-based activities and by activities in the subsurface space, and prone to being also interfered with when it comes to recharging and discharging. So the volumes, the quantities, the flow, the direction of flow of groundwater stands to be impacted by whatever happens above ground and whatever happens below the surface. These two, to my mind, are very prominent features of groundwater that makes it distinct to surface water and more complicated and complex to regulate.
Thank you, Stefano. Eric? Stefano?
Thank you. So that's the beautiful thing about the complexity of groundwater, is I completely agree with everything Stefano said, and I have a different answer, which I will add to it. I would just add to it, you can't see it, and that's not a joke. I mean, I think when with surface water and in a drought, you see surface water disappearing, and people will respond to that. But with groundwater, you can't see it, and it's available even when it's being overused. And so that makes it very hard to tell people not to use it when it's being overused, because it's still pumpable for the most part until it's not. The other thing is, if there's a serious drought, it is the supply of last resort, meaning if you tell people not to pump it, they have no water. And that's not, that is at the end of the day could mean death for people literally, or it certainly means a loss of crop, loss of business. So I would add those to what he said. It is just very, very challenging to regulate for all those reasons.
Thank you, Eric. It sounds like the main problem we're discussing private ownership, the inability to accept that people should not own maybe groundwater. If that is the case, how do we move forward? Is private ownership of groundwater simply incompatible with the issue of sustainability of groundwater research?
Well, I will argue that private groundwater ownership is very, very problematic for many different reasons, and I don't have time to get to all of that. So I will focus on 3 points that for me are the ones that I will say, yes, it's definitely incompatible, but not only with sustainability, but just with the necessities of current world, right? The current situation that we are in. First, I will say the problem of equity and distribution. As we know, and everybody that talks about water start with this phrase, water is essential for life. So of course, to drink, for domestic use, for agriculture, for industry, for absolutely anything that we do. So when it becomes private property, people have this idea that it's my property and I can access it and I can, have it as that I own it. That, of course, would affect the distribution, and some people that they don't have this, let's say, right of groundwater or the ability to pay will not have groundwater. So, of course, this idea of private ownership would lead to many different problems. For example, the absolute obvious is the exclusion of many households that they are in low-income communities, exclusion for people that they cannot afford it, and of course human rights concerns that I will talk about that a little bit later. So that was the first problem. The second problem, I would say, is ecological problems and depletion of groundwater. So of course private ownership incentivizes the maximize of profit, right? So if I own the resource, again, I will use it even if it's in an unsustainable way. So of course that will just put the resource in a very problematic situation. And of course it won't take into account the long-term sustainability of groundwater. And also something that is very important is that groundwater is not only needed for us, for humans, but we need to think about the non-humans world that also depends on groundwater. And finally, the third point is the public oversight or participation, accountability, transparency, all these characteristics that we need when we are governing groundwater, and when it's in a private hands, of course, that will all be more complicated and likely will reduce this public control of groundwater.
Thank you.
So I'll just add a little bit to that. I'm going to sound like Eric now. I don't disagree with any of that. However, I think one of the challenges, and this comes up maybe more in a later question, so I won't go crazy, but there are so many, what we found in this project is that there's already many governmental ownership and different property rights structures that frame this groundwater situation. And so sometimes I think talking about whether it's incompatible, it's important to understand the challenges that were just laid out, but also understand the structures or the limitations of changing that within a system that already exists. So ownership is a big word. We found in our surveys that it means a lot of different things in different places. But if you're looking at, I guess I'm the extreme situation because I live in Texas, so we really own it, whatever that means. So when you have a property right structure, I think one of the things that you can spend a lot of time thinking about, and that I would urge some of the conversation to move into where possible, is how do we meet some of the needs that were just laid out within an existing property right structure? What are some of the motivators or catalysts that we can use? A lot of times, and is there in fact a benefit or potential benefits if we're already in that structure that we can use to meet some of these very important needs. And one benefit of an ownership regime, so if I'm just playing devil's advocate like lawyers like to do, I would say if you have a good understanding of what ownership is, it actually can provide information that then can be part of whether it be a limited market, other regulatory aspects. We can look at it in relationship to surface water rights, which may be similar or may be different. So there are aspects of property rights that can kind of provide this sort of four corners. I think of it of this is now what you have, and then we can take some time to think about how can we use our understanding of that ownership to meet some of these other needs. And so that's where then you may not have within a regulatory structure the ability to abolish ownership without, at least in the US, major payments to individual holders. But can we use our understanding of that structure to then have policies in place to push things in a certain direction? Can we limit aspects of the ownership in order to meet some of these human right conditions? How can we use pricing to ensure that this human right to water, which I know we're getting to later also, is met without just spending time thinking about, is there a way to undo this entire ownership structure?
It sounds like you're saying that finally states have decided that they want to go and claim ownership over groundwater. That's interesting. They created regulatory systems and regimes for that. But is it not more just a fantasy if we consider that in many places within the countries that at least we surveyed, illegal pumping still takes place. Many kind of illegal other activities for groundwater also happens. Black markets are there for groundwater selling. So what are we discussing really when states or governments say, we own our ground, we own the groundwater? Is it actually, do they own it? Or are they trying to run away from accountability?
I believe in I think I'm gonna tell the case of Argentina. I think the public ownership that belongs to the provinces of the state, I won't define like that. I think it's very, very important that each state holds the ownership of groundwater. The great problem that we've got there is that hydrography and the implementation of the water law means you have different applications when you comes from a region that has a great abundance of water, like in Argentina. If you go to the west, you will have the ownership that the state is much more strong. They've got a very strong organizations in the water system, the water management, than from the provinces that they have a great abundance of groundwater. So I would believe that it's a very important, in my case, I believe, that the public ownership to guide what is about the management of the groundwater law.
Well, public ownership is a fantasy, right? Is that what you said for lack of enforcement? Let me just talk about the lack of enforcement piece for a moment, because it is an incredible challenge because the pressures on the resource are so great. So say in California, or most states in the United States outside of Texas, you have public ownership, and sometimes you have a permit system where people have to get permits to pump groundwater, sometimes not. But the pressures on it are huge, because you're dealing with either corporations, like I was just talking with someone before this started, data centers. Data centers are going in everywhere in the United States. They're going in all over the world. Everyone wants them. Everyone needs them. Everyone loves to use AI, and they take a lot of water, at least right now. So that's a huge problem, and that's going to create water problems where there haven't been any. And what you say to your local government, oh, don't have a data center, don't get the economic benefit, that's really difficult. Or in California, which is one of the largest agricultural economies in the world, it depends on groundwater. So if you're cutting it back, you're impacting food there, you're impacting, products around the world, and then you have human needs. So there's tremendous pressure on the governmental agencies in terms of regulation. I don't think that means we should get rid of public ownership. I don't think that means it's a pure fantasy. I think perhaps while not going as far as Texas, within that public ownership, you have to create elements of private ownership, as in permits or rights, and have an enforceable structure. But the challenge is really because of the importance of the resource and the, frankly, money and lives that depend on it.
Thank you, Eric. As we continue, I want first the public to reflect a bit on this question about how do we move forward? What's the best way to govern, regulate this kind of resource, considering all the actors and the factors that were mentioned by the panel? But then let's continue with this. Stefano, in Italy, the situation, there's like decentralization, you manage it, but also there's management at the local level. In Argentina, you have 23 provinces, there's a different way of management. Which structure works out? Do they work out for managing groundwater or not, based on what was said?
Well, surely off the cuff. Surely Italy is the best example of disintegrated water management. Total disintegration. So don't follow it. Don't take it as an example. It's the worst possible model for arranging governmental responsibilities from the center to the lower levels of government. And that came about as a result of devolution, actually, not so much delegation, but devolution of responsibilities of huge chunks of general government, responsibilities from the central level to the regional level of governments. Now, in Italy, we have 25 regions, if I'm not wrong, Francesco, 25. Let's see, three of which have a special status of autonomy, so they enjoy even greater shares of legislative, lawmaking, and executive powers than the other 20-odd regions. So, and among the powers that were devolved to the regions are powers in relation to managing freshwater, surface and underground. So now you have a situation where instead of having one, you do have one overarching, maybe a piece of legislation that's valid, for the entire country. But in actual fact, you have also concurrent legislation from as many as 20-odd entities at the regional level, 20-odd, regional laws that address aspects that in large part overlap with what, the national statute says. And you have 25-odd executives that are responsible for the implementation, administration, not enforcement, but implementation and administration of these several pieces of legislation. Now you say, well, what the heck? But in fact, the problem is that there is very little room for coordination from the center to the lower levels and at the regional level between and among the regions that share rivers or lakes or aquifers, because there are cases where rivers, aquifers or lakes are shared among regions, but there are no mechanisms embedded in the laws as such to ensure the necessary coordination. We do have, and in Italy we do have, basin planning, a system for river basin plans, but and perhaps so which actually are probably where the coordination takes place. But then these are just planning instruments; they have no binding force and effect. So in actual fact, what counts is action at the regional level by the regional executives that implement and administer regional legislation.
Stefano, does it work?
I beg your pardon?
Does it work?
No, to my mind, it doesn't. It surely doesn't, because there are conflicts. There are conflicts anyway. Conflict situations between and among regions over these fresh water that they share. And to my mind, that's not surely a model to be followed.
Thank you for that. Juan, does it work in Argentina?
I think in Argentina that it does work because the decentralization of water is related with a constitutional mandate. So every province has its own, is the owner of the natural resources. So this means water and underground and groundwater. So each province has its own water code. And I don't think this is a fragmentation. I think that every province try to manage as they believe the best practices they do. The societies are different. As I said,
Juan, what doesn't make it work exactly?
for example, I come from a province which is, well, as I said, I mean, there is the Guarani aquifer is there, but we don't have properly managed our part of the Guarani aquifer. So in Argentina, those things maybe try to get to national, matters, but every province that is the owner of each part of the Guarani aquifer should have more interest of it. But if you go to the west, which is the arid zone, like Mendoza, San Juan, nearby Chile, these provinces are very, very, very strong. They got a very strong public policies. They got a very good water management, not only surface management, but also groundwater management. So I believe that in the case of Argentina, it works very good, this implementation that each province has the ownership and the management of the water.
Well, that's interesting to construct contrasting examples. So we discussed public ownership, private ownership. How about the human right to water? How does that fit? Should that override public ownership, historical rights? How about that? What we do with the human right to water? Ladies.
I'm going to say yes.
In theory, yes. In practice?
Well, I guess I'm just the devil's advocate person, but of course I believe in the human right to water, but I think one of the bigger challenges that we've had is really understanding what it means, because again, I think you have to have pretty clear definitions and understandings of what it is that would be included in such a right. So living in an area where we do pay for, water delivery at least, the way that I think about the human right to water is based on a pricing system that is still would be affordable. And of course, that's going to range wildly depending on whether that water is being provided by a municipal provider or, is somebody drilling their own well. Generally speaking, for us, if you're drilling your own well, it's the cost of that actual operation is your sort of one-time investment, and once that happens, you have access to water. Obviously, in other parts of the world, that gets much more complicated, where water is even more difficult to access. So, to me, they're not antithetical. You can have property rights in groundwater as part of a legal estate, and also consider what an inclusion of the human right to water. Certainly there's places around the world that have included it in their constitution. And so it's really about thinking, well, what does that really mean? What is that minimum? Is it about affordability? Is it about quantity? Obviously it's about quality as well. So to me, they can absolutely coexist and has to be considered.
Well, maybe I will take a different approach, and I will say that, well, the question that you posed was, if in the case that, okay, there is somebody that doesn't have access to water, and that person says, okay, you cannot have my water because person A has the right to that water or the license, and person B cannot access that water because that person doesn't have the right and cannot get the right because maybe they cannot pay for that. So then I think is when the human right to water becomes interesting, right? Because if we could all coexist, I think there wouldn't be a discussion. The point is that we're talking about a resource that is very, very vulnerable, is limited, has been polluted, degraded, etc., etc. So sometimes there is a conflict, right? So how do we deal with that? And again, I think the concept of the human right to water is very interesting for that, because it gives the opportunity to people that maybe cannot get this right or this license because they cannot afford for it, but they can still have the water that they need, again, to survive, to satisfy their human needs through this idea of the human right to water.
Well, given this reality, I have a question for all the panelists right now. So what's the ideal groundwater model then? Based on all of that. We agree that there are a lot of problems. We agree there is public ownership, private ownership, how human right to water, many other issues we could not mention in the half an hour we have. What's the ideal groundwater model? Do we have one? Should we need one?
I mean, there's just one thought, maybe along the lines of the discussion you invited, but picking up from, the very last question, you're pointing, your question begs a big issue of reallocation, essentially. Let alone ownership. Ownership, if you own water and somebody needs water as a matter of human right, then you may raise an issue of expropriation, taking water away from one who owns it. But if groundwater allocation is regulated through user rights, and not ownership, you're talking about user, you're talking about licenses, permits, and all of that. These are user rights. Now, this begs an issue of allocation, initial, and reallocation after the initial allocation. So, when the issue comes, water is needed for other purposes, such as accommodating the human right to water. Then how do you take water away from those who hold it, not as a matter of ownership, but as a matter of rights? So to my mind, there's an issue of allocation and reallocation there, and how the law addresses this issue.
Stefano, are you saying let's go for a user-centric approach?
Well, but not necessarily a user-centered. No, what I'm saying is that the law, to my mind, ownership, to my mind, what's important is rather the notion that the state, the government, is the custodian of the resource. Whether under, pure ownership or trusteeship, or holds in trust for the public or owns it in trust for whatever. But the state, the government has to be the custodian, to my mind, of the resource. And that's where, most of jurisdictions point to anyway. Now, flowing from that come actually the fact that individuals or corporate users or whatever can obtain it's not so much ownership anymore, can obtain user rights, which are usufructuary type rights, from the government as the custodian of the resource. And if you have a proper system in place that weighs the pros and cons and strikes the right balance between different needs, also through a system of priority allocations, for instance, a statutory system of priorities, that's where you can accommodate the human right to water in case of competition. Think about South Africa's, for instance, the reserve for the human rights. There's a reserve for the human right. So the statute orders the government, essentially mandates the government to set aside volumes and quantities of water to accommodate the human right to water. So that's an issue of allocation and reallocation once the initial allocation is done. So to my mind, yes, the user right is probably real.
With this, we open for the public. We have questions. The first thing we want you to reflect on, is there a perfect groundwater model for groundwater ownership and usage?
Well, as I say, yes, I am Julio Herbel from Universidad de Córdoba. I am the president after this roundtable. Can you please show us a success case where groundwater is well managed and policy has improved the situation? Only an optimistic view, so we can have a nice lunch.
It's good to have optimism. Yes.
So you're from Argentina as well? No, I'm Spanish. So I will tell you I think in the Argentinian case, I think the example of what is a well-managed water, just not only surface, but on groundwater, is the province of Mendoza. I think they got the strongest water law. They've got a very well-managed, but I believe this is related, straightly related with the hydrography and the thought of the people. and they are very conscious since they are born to get to well manage the water. So I would say that in my experience.
Actually, another example might be Spain. Actually, I mean, in Spain, groundwater is very important. So and they have actually strong regulation of that, and some successful examples of user involvement, especially groundwater user involvement. That's probably the key, I think, to successful regulation, is involving the groundwater users themselves. And you have good examples there in southeastern Spain of that.
Okay, so more
Maybe
questions.
just to add that I think when we talk about what will be the ideal legal model, I think it's very important to look at context. So in every place it will be very different. I don't think we can say, okay, this is, and we should do it everywhere. I think we need to think that we shouldn't do that. In every case it will be different, and it will depend the many different reasons, from water availability to how many different users and for what uses and everything. So just to add on that.
Eric wants to add something?
Yeah. If I can just follow up on that really briefly, and also as Stefano said, it has to be user-based and it has to be local. There may need to be some higher regulatory authority to be the hammer if the powerful are taking advantage of the not powerful, which is what usually happens. But there has to be local buy-in. There has to be local user buy-in, or it will not work.
Question, yes.
And I think it has to be tailored to local science. So depending on what's going on with the surface water, groundwater, and whether it recharges. So it does have to be tailored.
Yes.
My name is Francis Njuakom, and I work for a non-governmental organization in Cameroon where we drill deep underground water and we provide to schools and to communities. I'd like to begin by thanking these discussions that are highly enriching, because they're clear that we face a lot of challenges in dealing with underground water. For us, we've developed a model in Cameroon with our work, in the sense that there are challenges and there are conflicts involved when drilling underground water. So what we do is that before we decide when a community approaches for water to be drilled within a community, we identify who owns the land. The community gets involved with the tribal leaders. We get involved with the government in terms of the local government, in terms of the local municipality and the mayor. So the Ministry of Energy, all these different actors come into play. They sign documents to prove that this is the owner of the land. The community too accepts to protect, to manage, to sustain the management on the groundwater by planting trees, and to ensure that there's a local committee that will be in charge of looking at this. So all these stakeholders come into play to avoid the issue of conflict management and pumping of water. Of course, there are in-depth scientific studies that are conducted to ensure that the water we get is clean, and also that surface water contamination because of various activities is taken into account.
Based on that, do you have a question for the panelists?
Okay, so based on that, I wanted to ask, so what can local governments and the civil society do to strengthen their efforts in ensuring that there's better and stronger sustainable management of underground water?
Thank you. Maybe a second question before we answering. Yes.
Yes. Thank you for the panel. I'm Guillermo Donoso from Chile. With respect to a model fits all, I think it doesn't. It depends on the socio-cultural beliefs of each country. You might impose it. But I wanted to ask, thinking of private ownership or public ownership. In the public ownership, you want to limit extractions based on a certain objective. But in the private, you could also limit, and that's my question, because I cannot do whatever I want with my property. So maybe both, it could be managed for the same objective?
Yeah, I totally agree with that. I mean, one of the benefits of having a really clear understanding of what the ownership interest looks like is opening it up to regulation. So the home ownership corollary is one that I use a lot, right? I quote, own my home, but there are significant limitations, at least in the US, of what I can do because of the police powers that are held by the local government. And the idea is my limitations benefit the whole, not just my neighborhood, but the city in general. So regulation and ownership are not against one another. You actually, regulation can be more specific if you have this clear idea. If you're already in the ownership model, I'm not advocating for that, but many of us are already in it. How do we then utilize that? So oftentimes it looks like it's adding an interest, but it's actually defining what the interest is so that then we can look at what these other goals are that have been described and work within that ownership interest to meet those objectives. Absolutely.
And I agree entirely. And in fact, that to me is yet another manifestation of the concept of the state acting, acting as a custodian of the resource, not the owner, custodian of the resource. So limiting, as it were, private property, if you like, in the interest of all.
Yes, another question.
Yes, thank you very much. I'm Bob DiFilippo from the University of the Philippines. Working in a decentralized water framework that I do in the Philippines, I'm just curious what suggestions you might have to engage stakeholders, because you mentioned stakeholders as a key voice. When we manage water, we know it's a local issue, both scientifically and culturally. I'm just curious what experiences you might share with us to improve that engagement. Thank you.
I just have one example, hyper-localized, but was a very big learning experience for me. We have an aquifer in Texas that has some really important stream flow and endangered species dependent on that stream flow. So while generally we don't regulate groundwater and surface water together, we had to in that case because of the Endangered Species Act. So one of the federal agencies actually put together a stakeholder group that lasted for 5 years. And I'll be honest, there had been so much contention around this, I thought this will never work. But over time, one of the most important things they did was to recognize who needed to be in the room. And it was a large stakeholder group. I think it was like 25 people. But over time, watching that group of people, so I would say you need somebody to convene that with the power to get people to show up. And there was this moment of, if you don't opt into the room, you can't come in later. And once that group congealed and became a unit, you couldn't, somebody from the outside just throwing rocks was not gonna get to that place. So I think really thinking through who the, not just political stakeholders, but social stakeholders are, environmental stakeholders, all of these pieces, and then really having someone that maybe does have a bit of a hammer that brings people into the room. We did agree on consensus-based, which that took about 9 months to agree to, but once everybody understood what that meant, that actually had its own service of making the group feel like a unit, because now we had agreed on the governance piece. So the governance piece has to be pulled up front. So those were just a couple of pieces that I saw that were highly impactful. And 5 years on, we have a really effective program.
Real quick, and in California, a little over 10 years ago, they adopted a statewide Sustainable Groundwater Management Act. So within that, in many basins, about 90 in California, there have to be the local agencies, so they're public agencies, so they're elected officials who have to respond to the public, have to form a local agency, create a plan. The plan has to go to the state and be approved. So it's trying to break it down to the stakeholder level, but with a framework that is also, responsive to higher level.
One final question. Yes.
Hello. My name is Sakar Hara and I'm from Nepal. And I was involved in my bachelor's level, the final year project, and we had done this little survey. So my question is a little longer. So, yeah. Okay, so there is a municipality and there are let's say there are two wards, Ward A and Ward B. And Ward A has the highest water sources. And Ward B has the highest population or population density. So there is a case that even though Ward A has the highest number of water sources, they have been receiving less water for their household purposes. So a centralized body has been managing that water system in such a way that more water goes towards Ward B, which has the highest population. So my question is like, how fair is it to Ward A, who has the highest number of water sources, and they've been receiving less water? Is it really fair or not? I'm just asking for your views.
Where does fairness? Thank you for complicating things that are already complicated.
I think you just identified a worldwide problem that people live where the water is not, for the most part, and then it has to be moved. So whether it's fair or not, that is a great question.
So where does fairness lie, essentially? Or can we be fair in this topic or not? Maybe that's a...
Well, I think there has to be an element of fairness. I mean, if you're completely depriving Area A of water, that's not fair. But if they have surplus water, then most jurisdictions it would be available for someone else to use it until they need it. So that's how that fairness typically gets balanced.
With this, we end the session. Thank you all for being here, and we're looking forward. Oh, sorry.
Just a few final thoughts to conclude this. I want to first of all draw your attention to the fact that there's such a diverse opinion, and it's not only because they're lawyers, but there is a different set of opinions from around the world in different countries and different jurisdictions that they do things in a different way. Much of it is based on local circumstances or local science. Other situations are based on nothing that we can recognize as reality, and we don't even know why they do things in a certain way. Many times it's because as I think was said, groundwater is invisible. We don't see it, and so we create rules without really thinking about what are the implications. And so as you can tell, that this is a critical project that we really need to get a handle of. How do we come up with regulations in relation to those local conditions? It doesn't mean that we can take California's model or Italy's model or Texas or wherever and bring it to somewhere else, right? But we do want to learn, and we learn under the circumstances of in Argentina, whether it's Mendoza or Misiones, or what is it unique about there? What is working or not working? Can we learn from that location? And maybe we can get some, and I like to say good practices, not best practices, but good practices that we can learn, and other countries, other jurisdictions can look at them and decide for themselves, is this something that might help us? That's the purpose of this project. We really welcome all participants. We want to have more engagement on this. If anybody's interested, please come talk to our participants here. Right now we have 17, I think, experts on phase 2, and so we've got a really good diverse group. But we are open to more. I want to thank all of you for being here. I want to thank our participants, our colleagues who are working on this project. I want to thank UNESCO, Abu Amani for the opening words and participation and encouragement for this project, and thank you for joining us today.